We are back with another moderator for next Qui Tam conference in Washington on February 27th and 28th of 2020. And we're with David Chizewer from Goldberg Kohn. David, tell us a little bit about your panel. It's on IFPA and CIFPA, right? What are these acronyms?
Right, those stand for the California Insurance Fraud Prevention Act and the Illinois Insurance Claims Fraud Prevention Act. And they are counterparts in a very major way to the federal and state false claims acts.
So what's the difference between these two statutes and the Federal False Claims Act and kind of state analogs?
So the federal government under the Federal False Claims Act has collected billions of dollars when whistleblowers have helped the government collect billions of dollars in healthcare fraud. And many of the schemes that companies have used to overbill the Medicaid and Medicare systems have also been implemented against insurance companies to overbill insurance companies. And people think, well, the government needs whistleblowers to assist them in uncovering this fraud because the government is a huge, underfunded, bureaucratic, organization that can't discover the fraud themselves. But people may think, well, but insurance companies, those are private companies with more of a direct incentive to uncover fraud, and yet we don't see insurance companies alongside the government bringing these claims and recovering the same level of dollars. And so I think, certain state legislatures thought, well, maybe we need whistleblowers not only to help government entities, but to also help insurance companies uncover fraud. Interestingly enough, you do see insurance companies in the healthcare area go after the single solo overbilling doctor who's using a more complex code to bill every single one of his services, for example. And you'll hear doctors who complain about insurance companies going after them. But those are sort of small dollars. They may be adding up, across the country, but it's interesting that you don't necessarily see insurance companies jumping into some of these really big False Claims Act cases where whistleblowers are, helping the government to uncover, hundreds of millions of dollars worth of fraud. And so I think, again, at least two state legislatures, California and Illinois, have thought, hey, let's see what happens if we allow whistleblowers to help insurance companies uncover this fraud.
So under the Federal False Claims Act, a individual stands in the shoes of the government. Here, how is this different?
Right, so the interesting thing is the legislatures haven't said, okay, well, if the whistleblower can uncover fraud against an insurance company, that somehow the whistleblower gets the insurance company's money like they do the government, because insurance companies, they're private, and insurance companies haven't necessarily agreed to allow private citizens to essentially get a portion of the damages that they've suffered. So the way the state legislatures have worked it is they said, okay, well, there are penalties, criminal penalties for defrauding insurance companies, and those can be monetary penalties, and those monetary penalties belong to the government. So as a governmental entity, as our legislature, we can assign some of that penalty money to whistleblowers if they help us uncover fraud. And then you're not really invading the insurance company's sort of private damages. You're really just giving whistleblowers a portion of the public penalty money for essentially, going against bad actors.
So if I don't live in Illinois or in California, but I want to blow the whistle on insurance fraud, do I care about these statutes?
Well, again, if you are incentivized, you don't have to be a resident of the state. If you know that a company within that state is committing some type of insurance fraud, you can uncover that and get a portion of the penalties that state would impose on the fraud doer. Again, you don't have access, you don't get an assignment of a portion of the actual insurance company's private damages, since those are private companies and they haven't agreed to assign to private citizens portions of damages that they've suffered. But because of the criminal aspect of fraud, of insurance fraud, and the monetary penalties that go along with that, you can recover a percentage of the monetary penalties, and sometimes the percentages in these insurance acts are even bigger than in the False Claims Act.
Wow. So tell us a little about your panel at the Qui Tam conference in 2020.
Right.
What can we expect to hear if we're in the audience?
Right. Well, again, this is a panel. We want to be objective and represent both sides, or really three sides. You've got defendants who are, accused of insurance fraud. You've got whistleblowers who are bringing the fraud. There's the insurance companies, and we're going to hopefully have someone on the panel who has represented actually insurance companies who have brought their own claims for their own damages under these statutes, as both a whistleblower and a damaged party, and maybe to try to give them a perspective on why do we need whistleblowers and why are more insurance companies filing claims under these statutes. And then we'll of course have defense lawyers who are defending claims under these statutes who will have their own perspective on whether these are a good or bad thing.
David, thank you.
Sure thing.
We look forward to seeing you on February 27th and 28th here in Washington at the 2020 Federal Bar Association Qui Tam Conference. You can register on our website at fedbar.org.